Do we have?
now. Sophie has brought some printed copies with her, so I didn't
Great,
take- I didn't
terrific.
Thank you.
Oh, you got one?
Oh, it's beginning to cool down in here. When it gets too cool, you are not even wearing a sweater, let me know.
Okay.
Okay, because look what Agatha brought, a heater.
Oh.
Just so you know, our sergeant at arms takes care of us, because it's been so cold in here. Luckily, people online don't get to experience
Bills
it.
that we have lying around.
You can have all the paper on my desk.
Well, oh, yeah. Thank you, Randy. Okay, welcome back, everybody. We are now gonna pivot to labor, and we're going to, we've had two of our labor bills voted out of the House, S-117 and S-125, and they have changed. They have morphed a bit in the House, and so here to explain that and explain what we're gonna be looking at, either to decide to concur or not concur, is our own legislative counsel, Sophie Zadani.
Yes, so Sophie Zadani for the Office of Legislative Counsel. And do you want me to put the bill up on the screen, or you have it in front of you? I don't know
You
what's-
gave us this,
Right,
and let's put it up on the screen, because I'm not sure everybody has a paper copy.
all right.
I don't think anybody has a paper copy, do they?
Nope, not handy.
No. So it's S-17 as has passed the House.
Oh, I didn't get it because you told me they were gonna be in, because
This is the House Commerce Amendment.
Yes, so I can just run quickly through. This was the bill that started off from the Department of Labor.
Yeah,
This was
technical
primarily
corrections.
technical corrections.
And Thomas represented it on the floor.
Yes. So the first four sections dealt with that expedited rulemaking for VOSHA. And so one of them was expedited rulemaking on safety, one was on health, and then there were two sections that essentially would repeal the changes. After 3 years. It was proposed to do a 3-year. There was interest on the Secretary of State to weigh in on those, and so the understanding is the Department of Labor and the Secretary of State are going to work together in the summer looking at expedited rulemaking. They had some concern, the Secretary of State had some concerns around it, and so those four sections came out. There were no changes, Section 5, Section 6. Section 7 was the sub-minimum wage.
Right,
And
which
you
had not been
proposed-
used for the.
Right, you had proposed eliminating the sub-minimum wage for individuals with disabilities. There was a question on the House side around, well, are we using it for learners and apprentices? The Department of Labor said no, and so the recommendation was simply to strike that whole subsection. There was, the Department of Labor had a request around potential layoffs, changing the threshold for when the notice to the department is triggered. There was some concerns around that, and the Department of Labor requested to pull that provision from
That,
the bill.
remember, we took it down to 20 to parallel with our small business.
Yeah, so they wanted to work more with the business community over that moving forward.
Okay.
Fine with me, especially if DOL asked to remove it over in the House, did they do the same with section 1 through 4?
Yes.
Okay, great.
Yeah, sections 1 through 4, the Secretary of State and DOL are gonna work on improving that.
Cool.
So the next few sections, there were no changes at all. And then we get to new sections, so section 21A, hope no one's looking at the screen because you might get seasick.
We're looking at your chart.
Yes, the chart is easier. So 21A, if you remember, we had, the committee had in 21 had moved the date for the unemployment insurance program, that's the modernized system, from July 1 of 25 to 26. And the Department of Labor realized there were other dates that needed to be moved that were in session law correspondingly. So section 21A is a new section that moves the other dates that had July 1, 2025 in them to July 1, 2026. And then these other new sections will seem familiar to you because these were sections that came out of this committee, but in Bill 125. So these were the workers' compensation changes regarding medical case management, where individual claimants can request to have medical case management services, translation services for individuals who are not fluent in English.
Can we stop on the English translation
Yes.
piece?
That's 23, section 23 now.
Yeah. And it's the same language that had come out of there in S125.
It's all our language they just put into this bill.
Yeah.
Because it belongs in house, because in the house that your jurisdiction is split between two committees in the house.
I just wanted to, the way it's worded here,
That's a summary though. on
it
this.
wasn't clear to me that it wasn't a civil rights violation. I didn't know what cost of translation services we were talking
Yeah, this
about
was to
here.
do with workers' compensation.
Right, but not to talk to the Department of Labor, because the Department of Labor needs to have their own translation services.
This is
This is
so
to-
that the insurance
to do the
carrier
medical
would provide,
case
right.
management. Okay.
And then moving forward again, the medical case management, that was unchanged. And then there was the section that had been in 125 around penalties for late payments of the weekly wage for those individuals on workers' compensation. That language didn't change other than actually some clarifying language. There was some, which I've got noted on here, but there was some language about, or if the payment is not mailed or deposited within 5 business days following the end of the pay period, the payment covers, and it was agreed by both the insurance industry, that do the insurance carriers, that it was kind of confusing the way it was written, and so this just makes it clear that you need to pay people on the date that's established, and if you don't pay them on the date that's established, that's when the late penalties would kick in. As the testimony in this committee was reflected in the committee on the House side, there was dispute around the extent of the problem around the late payment. And so 26 is a new section, and this provides that employers for 1 year will on a quarterly basis report any late fees that they have to pay for the late payments to the Department of Labor. The Department of Labor will then accumulate that information, and they will then bring it back to the General Assembly in January of 2027. So this is an attempt to get a sense of the scope of
Get
the
a really
problem.
clear understanding of the problem.
Right, and then an administrative penalty for employers that don't comply, don't do the quarterly reporting. And then the report that comes back will include the Commissioner's findings on how frequent late payments are, the reasons given for the late payments, the effectiveness of the late fee penalties in reducing the number of late payments, and then whether recommendations on whether to continue requiring the reporting, whether the penalty scale should be adjusted.
Great.
So those were the changes. The effective date changes only because originally when you had the VOSHA expedited rulemaking, you had that prospective repeal in, and that's obviously not needed anymore. So the effective date has shifted to just be July 1 of 2025.
So, and then, right, so, thank you, Sophie, for that. So committee, what's your pleasure? I think given that we passed pretty much all of this except for the clarifying languages that is in section 25 and 26, I would hope that we would consider concurring with the House on this one. Yeah.
I'm fine with that.
Good work.
David?
Yep.
Okay, great. So I don't think we need to take a vote to concur, although I'd be happy to. We do need to vote
Yeah.
to concur. So David, I know. Would you be kind enough, we just need a sheet vote.
I have a blank. That's okay.
Thomas, you okay continuing to report this?
I'd love to.
It's always nice to have a. So David, would you be kind enough to call the roll on the motion to concur?
Yes.
Senator Ron Hinsdale.
Yes.
Senator Weeks, yes. Senator Clarkson,
Yes.
500.
Thank you. And Thomas, I think, would you be kind enough to represent that today on the floor, and take this up with you? This vote, or,
Do we need a record of action on concurrence? Because we don't get the bill back in committee.
It's helpful to have.
I think
someone
you
can
say
ask.
it.
you need
Yeah.
to report it and ask Melissa what additionally, but I think,
I don't think I need to bring anything up though, right? No, I just stand up and say something.
yeah.
Hopefully coherent.
So Sophie, why don't you take, because I think that Kirby's gonna come back at 10.
So Kirby come in, I'm saying.
So I think we're gonna continue, and then Kirby will be right back.
I apologize, I'm logged out of everything, so sorry about that. Logged back in again.
Kirby is conferring.
Okay.
Pepper, would you be kind of to reiterate to Kirby, we're expecting back at 10?
Or is that?
Yes.
Or is he right there, ready to come back? Because I'd love, if we could finish on, this is gonna be, I think, a little longer. Okay, Sophie, let us, look at S125. Thank you.
Is
Sophie,
these your format? Because these are really great.
These are really helpful.
Yeah,
I have. no,
everyone
this is-
should copy your format
Crisp,
here.
clean, color coded. I love this. Thank you, Sophie.
Have you, is this
You have
now
to let me
standard?
in. Heidi, you have to let me in.
Oh, I'm sorry.
Is this now standard for Ledge
I
Council
made
or
it
just you? So feel free to share it with the rest of Ledge Council, which is, this is really
It's too
terrific.
comprehensible, so it won't fit. That's what we usually do.
So just, it's Friday.
Sorry about this, I did go out and I just, oh my God.
Oh, that's why I got confused. I forgot they moved that whole section down.
Alright, okay, you're confused, I was confused earlier, okay.
Well, I was like,
So this isn't yet the official version, which is still, it may be in the bins, but it wasn't quite yet. So this,
It
what
was okay, just to clarify, both these bills have been voted off the floor
Right.
of the House and are in the Senate and are en route.
right, and this bill was voted out, either yesterday or the day before. I think it was yesterday.
And just while we're at it, do you remember who in the House reported S117 from Commerce?
Yes, Michael Bosch, Dave Bosch, anyway, Bosch, B-O-S-C-H,
David Bosch.
Rep Bosch.
He was the reporter, okay, so Thomas, if you have any, I wouldn't worry about it, but anyway. And who was the reporter on 125?
Leonora Dodge.
Terrific, thanks. So let's go through 125.
All right. So 125 was sort of this committee's omnibus bill, but it had three pieces in by the time it left the Senate. So it had judiciary supervisors being able to organize and collectively bargain. It had a higher threshold for decertification under the State Employees Labor Relations Act. And then it had the certified payroll for state construction projects. So, and it also had the workers' comp, 4 sections that we just talked
Right,
about
that
in
we just took out.
F-117. Right, so to start with, it deletes the first 4 sections because those were the workers' comp sections that are now over in S-117. There was no change to the judiciary supervisors.
Although there was, in all fairness, quite a bit of discussion in the House.
There was
about this.
extensive discussion in the House on this, but it did not come out of the House's version of the bill. So this, right now, this is the list of employees that I'm showing on the screen is the Judiciary Employee Labor Relations Act. And like most of the Labor Relations Act, it sort of says who's not covered by it. So the definition of employee under that act currently excludes judiciary supervisors. And so the one word change in this section would be to eliminate supervisory employees, effectively meaning that judiciary supervisors can organize and collectively bargain.
Right, and we passed this, so there's no change from our language.
No change from, right.
Can I ask, their change in status, meaning they now have the ability to organize if they choose, doesn't change any of their other employment wages, working conditions, hours.
It means that if they wish to organize, they now would have the ability to organize. It doesn't force anybody
Right,
to organize.
right.
So.
And it doesn't change their exempt versus non-exempt
No,
status for any other
Right,
purpose,
that
unless
would-
they choose to join.
right, anything on wages, working conditions,
Right.
any changes to that would then be determined at the bargaining table.
Mhm.
Okay, next section, no change.
The next section was the section that under the State Employee Labor Relations Act, and again, we have 7 labor relations acts in Vermont. So under the State Employee Labor Relations Act, what this provision does, which again, no change, but what it does is increases the showing of interest that's required to decertify a union. So that could be either the employees saying they don't want to have a union at all, or they want to have a different union come in. And so right now, to certify a union, you need a petition of 30% to go to the Labor Relations Board to trigger a secret ballot election. This increases the decertification to 50%, +1.
+1.
Right, don't forget the +1.
Are we talking about the new sections now?
No, this is
Oh.
what you passed out. It sets up in
Yeah.
the sections, that's why I'm
Okay.
explaining.
And then the state, our certified payroll got pulled.
The certified payroll was pulled in 5B. But then the addition was to mimic what had passed out of the Senate on the State Employee Labor Relations Act and extend that to all the other labor relations acts. So the additional sections add that change from 30% to 50% +1 to trigger a secret ballot election under the other labor relations act. So again, I don't know how much detail you want to go into, but 5C covers the Judiciary Employees Labor Relations Act. 5D covers the Teachers and Administrators. 5E is the State Labor Relations Act. 5F is the Municipal Employees Relations Act. 5G is the Independent Direct Support Providers Labor Relations Act. And 5H is the Early Care and Education Providers Labor Relations Act.
What's an independent direct support provider?
That is a unit that the last two there are sort of unusual ones. So those are for individuals that provide direct support. And I don't have the information off the top of my head, which I can certainly get to
Wouldn't we
you.
just call it home care workers?
These are right. They're people, so they're able to, as a sector, work
It's
directly with the
Mhm.
state to negotiate over their reimbursement rate. So it's a very sort of limited purpose kind of unit. So they are organized. My understanding is the Early Care and Education Providers Labor Relations Act, although that act has passed, no one has organized under it. So that's, but so essentially what the House has done is just extend the decertification threshold across all 7 labor relations acts.
Okay, so they took what we did for one union. And and have expanded it to
The 6 other.
the 6 others.
Yeah.
Okay, and, thoughts, committee?
Looks good.
Thomas?
Yes, so I'm fine with this.
Do we want to sit with this? We don't need to rush on this, and I don't know if it's on our calendar. We could, I don't
I
think
don't
it
believe
is.
it's on for today.
So we don't need to land this at the moment. If you want to hear any testimony on this, because this is a bigger change than the other one.
Which part?
Well, adding all these other unions, we've added 6 more.
Remember, we had
I mean,
a fair discussion.
I think it makes it consistent.
When we
Mhm.
went to 30%, there was discussion as to whether 50% +1 was too high for simply a decertification vote. It doesn't mean you're decertifying, it means that it's
It's
just
just
calling for an
Yeah,
election.
exactly. It's like the opportunity to organize.
It's very much like the card check system in reverse. And whereas the card check system required, 30% in order to get an election, we're saying it requires 50% +1
To
to get an election in the other direction.
Right.
We did that because the proponents said that one of the problems they were having with this particular group was that they felt that they would be in an election every other week, as opposed to something more permanent. I don't know whether this argument applies to all the other groups, because we really don't know much about any of the other groups. So I think it's worthwhile just thinking about this for a minute rather than acting reflexively. It may be okay, but at the same time, I think we gotta think about it.
Okay. We can certainly discuss and have VSEA come in on Tuesday and discuss this further. It's not, I don't believe it's on our calendar. I don't know if anybody's checked, but it's 117 is a day or two ahead. So 125 there's no immediacy.
Yesterday.
125.
Yes, I'm losing track of which one.
They voted
They've
it off
both been
before,
kind
but
of-
I'm not sure it's actually to us yet.
It's on our calendar.
I heard.
No, that's on our agenda for today.
Oh, yeah.
It's not on the Senate calendar.
Oh, right.
It was at
Well,
second.
what do you have, it says when
It's
reacting?
done third reading.
Oh.
It's done third reading.
It's
It's
voted
out.
out of the house, yes.
It's out of the House, it's to us, the question is it actually to us yet? So we have a day or so on
Understood.
this.
Thank you.
Well,
It'll be noticed on Tuesday and up for action. Or
Okay,
scheduled
that's
what I was
Wednesday.
Oh, good. And I agree with Senator Brock's comment, taking a day to think about it.
So, and if people want to identify with, Heidi, you mean who you want to hear from, we'll hear from.
Just a question.
mistaken, it's on notice
Also
today.
regarding
it's
section
on notice
5B.
today.
Did I hear you correctly, Sophie, that there are no unions under the Early Care and Education Providers Labor Relations Act?
I believe that's right, yeah, I don't believe they've organized yet.
If it's on notice today,
It'll be up for action on Tuesday.
and we won't have committee time before that.
We will.
We will?
We're gonna have committee time from 9 to 10.
On Tuesday.
Yes.
Is Tuesday at 10 now, not 9:30?
My understanding that is we've switched to 10 o'clock for the entire week.
For
Okay, you're right, okay.
If we
so 9 to 10.
haven't, we can do something else. But I would suggest we have an opportunity to think about it and weigh in and make our decision on Tuesday.
I guess why wouldn't we do that today? We have an hour.
Well, because we haven't had the opportunity to think about whether or not we want to have any witnesses.
you're gonna do some pot.
Okay, so I need.
I don't even know what independent direct
Leave
support
room for
providers
thought.
are.
Okay,
Do you?
so, may I make,
Who are the independent direct support
It's the home
providers?
care workers,
It's the
we
home
were
care
both there
workers.
when we
The what?
allowed them to unionize, it's home care workers.
Home care.
the SEA has just walked in the room.
Alright.
So we can either continue this conversation right now, or switch to our voting out our cannabis bill. We could take 1 second of testimony from our VSEA lawyer who has just arrived. And I think we have a couple questions on S-125. We have concurred, we have voted to concur with 117. But we have a couple questions. If you would just join Sophie can stay right there. If you would just join Sophie and introduce yourself and get ready for a few questions.
We will field them as adeptly as I can, Madam Chair. It's Tom Ablenor, for the record. I'm the legislative coordinator of Vermont State Employees Association.
Randy?
Just questions in terms of, I think I just heard from Senator Ron Hensdale that the independent direct support providers are home care workers. Is that correct?
Yes, I believe that's correct, Senator Brock. And I will just say the changes, my understanding of their changes to that section stemmed from a desire first articulated by Representative Bartley in the General Committee that if the thresholds were being changed for decertification, that she had a desire for uniformity across all of the different bargaining
Consistency.
That's right, consistency, Madam Chair. Better put is consistency. Across all the bargaining units rather than simply in the State Employees Labor Relations Act. So she suggested, and the committee agreed, that in one fell swoop, they should change it for all of these rather than having to come back at some point in the future and say, oh, well, it doesn't exist currently in the judiciary statute or municipal statute. They figured consistency across the bargaining statutes.
Well, as I recall how we got to the 50% plus one in the first one of these that we did, which were employees in the Attorney General's office, as I recall. It was I don't know whether it was them or another group, but I remember the testimony was specific that the reason we wanted to change it because of the fear that we're gonna have to be back constantly because a small group of people, like 30%, would keep repeating it. But it was based on the nature of that specific group, not on the basis of all groups, as I remember the test, but I think you were in the committee, is my recollection correct?
Well, I think you're definitely remembering, portions of my testimony
Mhm.
correctly, Senator. I did say that there is a fear sort of across the labor movement nationally
Mhm.
of, too frequent decertification attempts brought forward by a vocal but small minority.
Mhm.
I think there is a distinction, though. It didn't have to do with the assistant attorneys general
Yeah.
who were under consideration in the bill for a different aspect of this legislation, which would have allowed them the opportunity to
That was
organize.
another group?
It was a concern really about decertification writ large. And then there was a different section of the bill that involved the assistant attorneys general and whether or not they could.
But as I
organize.
recall, what I heard was that there was a particular group that you were concerned about, the 30% because of a past history of the smaller group being at odds with the larger group.
I think, Senator, that just in trying to recapture my testimony accurately, it was not so much that we were concerned with a particular group as it was that our experience with decertification efforts on our units previously, and also the broader sort of trends nationally, made us concerned about that issue in general. The specificity came in with the different groups that we were trying to allow to have the ability to organize, one of which is still in the bill, the judiciary supervisor.
Well, I think in particular, I sort of was thinking about equity and how we do certification versus decertification. And with card check, for example, 30%, and the purpose is not to decertify, but to allow people to bring up so that there can be a vote to decide whether or not to continue or to decertify. And
I just
the
wanna
notion
make
that
sure,
the-
so the threshold, you're saying,
Yeah, that the
I just wanna
threshold,
confirm that the threshold for expressing interest in holding an election to unionize is 30%?
yes,
Under the current statute, 30% triggers a decertification election.
Sorry, but you're
But no,
talking
he's
about
talking about the front
forming.
end.
He's talking about the front end.
yeah.
At
I'm sorry,
at the moment,
Yeah.
when it comes to certification, there are two mechanisms under current Vermont law that allow certification. One is a 30% showing of interest to then hold an election to certify. And the other, passed by this body about a year and a half ago, is card check, which, as Senator Chittenden is aware, allows people to, with a 50 plus 1% vote, organize, certify through that mechanism rather than the need for an election.
Right, yeah, correct, I understand.
So the 30% threshold is a one-time vote rather than card check.
There are two different separate
They're both
mechanisms.
card check.
No, not, I wouldn't say that, Senator.
Mhm.
There are two different mechanisms under the law right now in Vermont that one can certify a unit. One is the 30% showing of interest, which generates a certification election.
How, is that a Australian ballot or?
Yes.
Okay, so that's, I think,
That's what I'm talking about.
yeah, so
That's
you're
what
saying the 30% Australian ballot is kind of,
Well,
Different.
just to be clear, it's not
Not script,
right.
Oh,
It's a sign up.
The 30%
Okay.
is a gathering of cards,
okay,
expressing interest.
Interested in it, and
which then triggers
Okay.
the election. But I will just say, with regard to certification, I don't want to say it's been supplanted by, but a common way of organizing at this point, since card check has come into place,
yeah,
is to certify through card check.
with the 50% plus one.
Exactly, Senator.
I know you don't support this, but given where I'm seeing the politics are, I think what would be reasonable and equitable is if we could decertify at 50 plus one.
So
I know
if-
you don't want that,
well,
but
so-
I'm wondering if that might get enough people to be on board with this.
So, Senator, I would say that would be an incredibly dramatic change that would put Vermont, would overnight make, just to be clear, and
You see my point?
I understand your point. If we were to go that route, Vermont would overnight become the most restrictive state in the country when it comes to decertification. of
Senator
unions.
Chittenden loves
You don't
to
support
threaten
that.
There's not
to
a single
split the baby.
There's not a single state in the union.
He's
that-
always trying to split the baby.
There's not a single state in the union that does that. It would make it easier to decertify a union in Vermont than in any place in the country. And it would be a dramatic and a change that we would oppose with all of our vehemence. We would absolutely oppose a change like that.
So, I'm sorry, I just had to warm up my breakfast. So we are at where we have answered Randy's question?
I believe so.
And so that this came from the House. Ashley Bartlett, the Vice Chair of House General, had suggested that this be consistent among all our union groups in Vermont.
That's exactly correct, Madam Chair.
And however, there is one union group that is yet to be formed.
These are changes to the statute,
Mhm.
so
We
it
gave
just
permission.
makes,
Okay,
right,
just straight, okay.
so, yeah. So again, this is, just because no one has organized under it, the statute is still there.
And that's the early care and
Yeah,
education
that's right,
providers.
it's not organized, right, yeah.
So-
Yes, my understanding is that they have not.
Thank you. Okay, so anything further on this before we switch back to cannabis? Are people comfortable taking a vote to concur or not to concur?
No, I'd like to have a day to think about this.
Yeah, I think we need to give people a day. So we're hearing from the unions, we have to give an opportunity for the employer groups
Okay.
to voice. That's fair.
Just fairness.
For efficiency's sake, I think there's a good chance over the weekend we will hear from some judicial folks. I think we've already all gotten an email from
They're
one.
in your inbox.
I already responded to them that nothing requires anybody to unionize. It just gives them permission to do that.
Correct.
Did you have any other discussion with that employer group, or did that come up in the committee?
Well, I will say a couple of things about the judiciary piece.
That's now in, okay, that's, sorry.
No, that's fine. I'll say a couple of things about the judiciary piece. The judiciary made extensive arguments in front of the House Committee on General and Housing and the House Committee on Judiciary, expressing their deep concerns and hopes that they would not allow these groups of their employees to organize. Those committees considered those arguments at length. They took testimony at length and decided, with regard to the judiciary supervisors in the House General Committee, on an 8-1 vote, to include the judiciary supervisor piece in the bill, as this committee did when it considered the bill. The Judiciary Committee similarly said that they had no intention of blocking that, and it passed the House successfully. So I will just point out that there is no conflict in any way between the House and Senate versions of the judiciary bill. They are completely in concert.
Right. I just wanted to preempt some of the emails that we're getting, which,
Prepare people for them.
well, we have a witness who.
But your point is-
That's helpful to know, I mean, because they still say, we have no idea and nobody's given us the chance to speak.
It's been discussed at to a quite extensive degree, I would say, Senator, with all arguments laid out, considered, and in the judiciary's case, ultimately rejected by the two committees that considered them. I will just say as well, your point is exactly correct, Senator. In the event that folks do not want to be a part of potential future union, they need not join a potential future union, and they could vote no in any vote to organize a bargaining unit. I will point out, though, as well, this is not just about the individuals currently in positions in the judiciary. This is about the right of supervisory employees in the judiciary now and for the rest of time to organize if they want. So in the event that the folks currently there decide that they don't want to organize, that's fine. The VSCA, is not in that practice of attempting to organize bargaining units where people don't want to be organized. No unions are. But if every person there were dead set against it, which is, I can assure you, very much not the case, the future employees of the judiciary who are in supervisory roles would still be granted the right we think they deserve at this point, which is to organize.
Well, and that is our constitutional change we made as well.
And I also understand that, am I correct in understanding that supervisors across state government are all able to
The
organize?
supervisors in the executive branch, Madam Chair, have had the ability to organize, which they did for the past 50 years, where the supervisory bargaining unit, as represented by the VSCA, has bargained any number of contracts and with no issues
So,
whatsoever.
and so this is again, sort of like
Parity.
Ashley's proposal on the other piece
Exactly.
to make it consistent.
That's
I just
correct.
wanted to reinforce that piece.
I would just flag that that is certainly true for the State Employee Labor Relations Act, but the supervisors are excluded from bargaining under the State Labor Relations Act and the Municipal Employees Relations Act, so it's not uniform. I just want to.
God, thank you.
I-
But
I-
it's up to the labor relations board.
With regard to the state employees.
Yeah, right,
The folks
Right.
we're considering in this case, it has been the case for 50 years.
Right,
yeah.
so in the interest of time, I honor the request to have this addressed again Tuesday at 9 o'clock. And if people are wanting to
So we need to
testify,
put that on our calendars.
yes. So we were gonna discuss that after we got the candidates, but gonna have a little committee check-in. So, thank you, Sophie, thank you, Tom. And thank you for cannabis, crowd patience while we dealt with this and Kirby had the chance to rewrite. So, thank you. We'll revisit
Thanks,
this
Tom.
again Tuesday at 9. And if people want to testify, please be in touch. Thank you. Have a great weekend if we
Thank you,
don't
Madam
see you.
Chair.
Tom,
What do I do?
what? Oh, no, it was Tom, it was the other
Oh,
Thomas.
that Thomas.
It was the other Thomas. Okay, Kirby, thank you very much. Come join us again at the head of the table. You know, there is that little tray that Finn Saluzzi always is reminding me exists for your computer. I mean, if that's useful for people.
Oh, you mean I can spread out?
Hey, wait.
It's helpful for Thomas, so feel free to use it if you'd like. Thank you. Thank you for being such a speed demon. Is today the
I've
sixth?
drafted in much worse conditions.
I can't believe it's the 16th.
That's
What
probably
is
worse.
happening with our,
At midnight or whatever that
okay,
was. Okay, so Kirby Keaton Legislative Council, I was asked to create a new version of the committee's amendments. You'll have, so we're looking at draft 6.2. I believe it's being posted. Right.
thank you, Heidi.
There are 3 changes from the version we were looking at before. The first is on page 1, removing the spillover beyond forecast from the excise tax, with the understanding that a different
Yeah.
variation of that will be handled in a different committee. The next change from what we looked at before is on page 2, around line 16, where I removed the creation of the special fund for the Land Access and Opportunity Board, but kept the addition of the new member.
Great.
And the last change is I added a subsection F to the event permit session law that reads, the board shall prioritize social equity
So,
applicants.
sorry, which page are you on?
I'm at the top of page 10.
Yeah.
Line 1. The board shall prioritize social equity applicants as defined by 7 VSA 911 and any related rules when deciding whether to approve an application under this section.
Thank you.
So this is referencing the statute that was discussed before. I've been told, although I didn't personally check, but I've been told there are rules related to that section that the board has created. And the way this is written, to make sure I captured your intent, you specifically wanted this to relate to approvals. And the way that I wrote this, to approve an application that would apply to permit applicants and the retailers that are participating in the event, to the
Great.
extent that they're applying.
Yeah, I think that's great.
Thank you.
Ready for a motion?
Yeah, I just want to check in around the room. How are we? We okay? There's five, with our 5 instances of amendment? Great. Terrific. Yes, committee, before
Want
we,
to drag this out for another hour or so?
My kids are out front, so. Hi, Phoebe. Well, one's asleep, thanks to Jean in the other room, but the other one is on the lawn.
Gene, I have to say thank you on behalf of the entire committee for
Yeah.
your kind administrations.
Madam Chair, I would move favorably for committee report of draft number 6.2 on bill H321.
Thank you. Any further discussion?
I'm glad we took the time
Yeah.
on
Absolutely.
this one.
I was
Thank you.
hoping, as you
Thank
all
you.
know, as you all know, I was hoping to get this out on Wednesday.
Very educational.
Yeah, it's
I-
becoming a market at Still. and
It's
we
an
need to work
important
on that.
market and one, yes, it's an important market and we are hopefully continuing to support it, not perhaps as fast or as furiously as others would hope, but I think we're doing it the way we can at the end of the year. Clerk, would you be kind enough to call the roll?
Yes, ma'am. Senator Brock,
Yes,
Senator Chittenden,
Yes.
Senator Rom Hinsdale.
Yes.
Senator Weeks, yes. Senator Clarkson.
Yes. Thank you very much. Now, I have a tradition of representing the sins on the floor. Liquor, lottery, sports betting, so, you
This
know.
isn't quite as simple.
No,
as
yeah,
those,
but
I
you know,
think.
we all refer to them as devices. Okay, devices. Either way, I'm happy to take this on because
Great.
as everyone
Because
knows, it's
whatever.
not my great area of expertise. I'm perhaps the least qualified to do it, but I'm happy to do it. With
We'll have to
people's
work
help.
on that.
What?
We'll have to work on that.
You go to this pop fest.
We, you know, we just have to change the law and then we can all go right out to the smokers corner and.
I have had, as a result of this discussion over the last several weeks, I've had 2 offers to go visit farms.
I just got my first today.
Maybe we could go together.
All right, let's do it.
well, I've added to my resume, vice chair of the vice committee.
You know, Randy, if you want to report it, you're welcome.
I don't want to report it.
I was serious about my daughter.
Oh, no,
on
oh,
the
is
front
Vera
lawn.
here?
Yeah, yeah,
Oh, how exciting.
yeah.
Okay.
We have a break?
We have a break and then I'd love to come back just to talk about what we're up to next.